For those of you who are fortunate enough to have never received a lawyer's letter, in this vlog I'm going to break down why they are the most foul pieces of writings on earth. And as the perfect example, we are going to use Rachel Maddow's response letter to the OAN's letter of demand in the defamation lawsuit OAN has filed against Rachel Maddow, MSNBC, and the other entities there. Viva Frei, Montreal litigator turned YouTuber, and I'm going to be talking a little softer today because it's a car vlog and I've got somebody in the back sleeping who was being a little bit of a cranky pants this morning. I like to say that lawyers' letters are like dirty diapers. It's fun watching other people struggle over them, but it's not quite so much fun when you have one right under your nose. Lawyer letters are obnoxious, they're sassy, and you know that once you get one, it's going to cost you a lot of money. But there is an art, an insidious art, behind a well-drafted lawyer's letter. And I want to walk you through all of the beauty, the nastiness, the do's, and the do-not-do's of a properly drafted lawyer's letter. Now, for those of you who don't know, the OAN, which is the One America News Network, is suing Rachel Maddow, Comcast, NBC Universal, and other related corporate entities on the basis of defamation for things that Rachel Maddow said on one of her shows. On the Rachel Maddow show, Rachel Maddow quite literally referred to the OAN as really, literally Russian propaganda. The OAN did not take kindly to the accusations and sued Rachel Maddow, Comcast, and the other entities for defamation. Now, I've already done a vlog breaking down that lawsuit in great detail. I'm going to link it right here if you haven't already seen it. I went through all of the allegations in that lawsuit, but in this video, I want to go through one lawyer's letter in particular. Now, when it comes to lawsuits in defamation, what you will notice oftentimes is that the plaintiff, on their own or through counsel, will give the defendant an opportunity to retract the allegedly defamatory statements. And the reason for this is that if the plaintiff just jumps right into a lawsuit for defamation without having given the defendant the opportunity to take cognizance of the allegedly defamatory statements and to retract or correct them, a judge might not necessarily appreciate that type of zeal to institute legal proceedings. Also, when it comes to the damages that the plaintiff can claim, if the defendant was notified and advised to retract and or correct and they refuse to do so, that will exacerbate the damages the plaintiff can claim from them. So there is a strategic reason why you will notice that certain plaintiffs have given the opportunity to the defendants to correct their allegedly defamatory statements. And in most circumstances, if the defendant does in fact retract and or correct the allegedly defamatory statements, typically the plaintiff will not actually sue. More often than not, given the egregiousness of the allegedly defamatory statements, all of the plaintiff wants is the record to be corrected. They want the public to be notified. And so if and when a lawsuit for defamation is filed, typically it's because the defendants want to get stubborn, they want to play their rights, and they don't want to retract and or correct the defamatory statements. And the situation in the OAN versus Rachel Maddow, Comcast, NBC Universal lawsuit is no different. Indeed, prior to filing the proceedings, the OAN did in fact send a letter of demand to NBC Universal, Rachel Maddow's lawyers, advising them of the allegedly defamatory statements and giving them the opportunity to retract and correct those statements. It's one of the exhibits to the lawsuit. We went over it briefly in my original vlog on the subject, but it is a July 25th, 2019 letter. And the letter is entitled Notice to Retract Defamatory Statements. Oh, I see somebody moving. Daddy. Regarding One America News Network. Oh no. Just want a vlog. All right, we're gonna see how much quiet time I can get indoors. I would say chances are 50-50 I'll be able to finish this vlog today. What do you guys say?
That's more like 25.
The OAN's letter of...
I'm gonna go paint this. It's gonna take about 5 minutes, so...
Take 15 minutes, please. 15 minutes? You can do it in 15 minutes? All right, so the OAN's letter of demand to Rachel Maddow, NBC Universal, et al. That means, and others. Via certified mail and email. Rachel Maddow, The Rachel Maddow Show, read notice to retract defamatory statements regarding One America News Network. Something interesting I noticed in both the original letter of demand and NBC Universal Rachel Maddow's response letter is that neither of these letters say without prejudice in big, bold italics writing on the top. As an attorney, I happen to be of the opinion that without prejudice sort of stamp is really more or less useful, especially when you're dealing with other experienced attorneys. It does have something of an intimidation factor when a lawyer is writing a letter to someone who they know is not yet represented. But everyone in the industry really understands that without prejudice means absolutely nothing. And to those that are not in the industry, there is a big misconception as to what that term without prejudice actually means. A lot of people think that they can slap without prejudice on a letter and it means that it can't come back to hurt them. That is 100% false. Labeling a correspondence without prejudice does not mean that you can say whatever you want in that letter and it cannot be used against you later on. Labeling a correspondence without prejudice means that you are not being limited to that which you allege in that correspondence. So typically someone writing a letter of demand or a cease and desist letter will put without prejudice on the top, in that they will not be limited to the grounds of attack or defense in that letter. If they forget or for whatever the reason deliberately omit to include certain accusations, they are not precluding them from raising them at a later date. That is typically what without prejudice means. But it is not the case that there is any legal requirement to put that stamp without prejudice in order to benefit from that sort of protection. Whether or not you put without prejudice on a letter, you can still raise additional grounds of attack or defense at a later date. But if you have only one takeaway from this entire tangent, you cannot put without prejudice on a letter, then make all sorts of stupid admissions, and then think that those cannot be held against you at a later date. Period. Wrong. Don't do it. Don't do it. Don't do it.
Back to the letter.
Ms. Maddow, please be advised that our firm has been retained by One America News Network concerning the July 22nd, 2019 episode of The Rachel Maddow Show in which you maliciously slandered OAN. This letter serves as a demand that MSNBC, by and through yourself and or otherwise, publicly correct your defamatory statements in accordance with California Civil Code Section 48A. So here, above and beyond any strategic reason for giving the opportunity to the defendants to correct their defamatory statements, there seems to be a statutory requirement to do so. 48A. In any action for damages for the publication of a libel in a daily or weekly news publication or of slander by radio broadcast, plaintiff shall only recover special damages unless a correction is demanded and is not published or broadcast as provided in this section. Plaintiff shall serve upon the publisher at the place of publication or broadcaster at the place of broadcast a written notice specifying the statements claimed to be libelous and demanding that those statements be corrected. The notice and demand must be served within 20 days after knowledge of the publication or broadcast of the statements claimed to be libelous. B. If a correction is demanded within 20 days and is not published or broadcast in substantially as conspicuous a manner in the same daily or weekly news publication, or on the same broadcasting station as were the statements claimed to be libelous in a regular issue thereof published or broadcast within 3 weeks after service, plaintiff, if he or she pleads and proves notice, demand, and failure to correct, and if his or her cause of action is maintained, may recover general, special, and exemplary damages. Exemplary damages shall not be recovered unless the plaintiff proves that defendant made the publication or broadcast with actual malice, and then only in the discretion of the court or jury, and actual malice shall not be inferred or presumed from the publication or broadcast. So here we see that there is some form of a statutory requirement to provide notice and the opportunity to the defendant to retract or correct the statements. Failing such notice, the plaintiff may not be able to claim or be awarded certain types of damages. And for those of you who may not know the details, and for those of you who do, just briefly, Rachel Maddow on one of her Rachel Maddow shows said that the OAN is really literally Russian propaganda. She said this on the basis that one of the reporters at OAN used to write for Sputnik. Sputnik is a Russian-funded news entity, and that the OAN, by employing this reporter who used to write articles for Sputnik, really literally is Russian propaganda. I will screenshot the initial letter of demand so that you can read it in its entirety if you are so inclined, but let's just skip to the last page. Your assertion that OAN is a Russian propaganda operation is utterly false and defamatory. Our client will not stand by and allow these lies to be disseminated. We hereby demand that you, 1. Immediately cease and desist in publishing defamatory statements about our client, whether the statements are made by you or by third parties. 2. Issue a public retraction of the defamatory statements, making it clear that OAN is not paid Russian propaganda. This letter puts you on notice that should you refuse to comply with our demands by August 15, 2019, we will recommend that our client pursue all legal avenues to protect its interests, including damages and attorney's fees and costs incurred as a result of your actions. We reserve all our rights and remedies. And here you see at the end of the letter they reserve all of their rights and remedies, which is sort of the without prejudice header that you might see on most other letters of demand, and I always say you do not need to reserve any rights that you may have. If you have the rights, you don't need to reserve them. If you don't have the rights, it does no good reserving rights that you don't have. But now let's get to the response to this letter of demand, because it is a thing of legal beauty. Dear Mr. Miller, I am writing in response to your July 25, 2019 letter concerning statements made about your client, One America News Network, on July 22, 2019, during the Rachel Maddow Show on MSNBC. While discussing an article published that same day by the Daily Beast concerning OAN reporter Christian Ruse's simultaneous employment with the Russian government-funded outlet Sputnik, Ms. Maddow expressed her reaction to this report by stating that OAN really literally is paid Russian propaganda. Your letter claims that this statement is false and defamatory. Your client, however, cannot state a valid legal claim for defamation. And let me just pause here to say that there's nothing more humorous than being told your rights by the adverse party's attorneys. Just once, I would like to see the opposing counsel accurately and fairly tell me what my rights in fact are vis-a-vis their client whom they represent. But who knows, maybe Maddow's attorneys are right. Let's just see where this is going. Your letter acknowledges that Mr. Ruse writes for Sputnik. Indeed, it makes clear that Mr. Ruse has written 1,300 articles for the outlet, which is nearly 1 article per day for the past 4.5 years. Importantly, your letter also does not dispute the fundamental fact that Sputnik is funded by the Russian government. The United States intelligence community has determined that Sputnik played a key role in the Russian government's interference in the 2016 election, and the Department of Justice ordered Sputnik's affiliated U.S. entities to formally register as foreign agents. Mr. Ruse's compensation for more than 1,000 articles he wrote for Sputnik was essentially paid for by the Russian government. Par for the course, any reasonably competent attorney is going to look for admissions in the opposing party's correspondence. And this is where I go back to the without prejudice being useless. If there are in fact prejudicial admissions in that initial correspondence, without prejudice is not going to save that party from them. You also do not dispute that Mr. Ruse is employed by and writes for OAN. Indeed, you state that his job includes collecting and analyzing articles from other sources and writing articles for for OAN based on those other sources. OAN therefore publishes content collected or created by a journalist who is also paid by the Russian government for writing over 1,000 articles. Ms. Maddow's recounting of this arrangement is substantially true and therefore not actionable. Here I have to point out a very subtle intellectual sleight of hand, and it relates to the tense of the verbs in the allegation. OAN therefore publishes content collected or created by a journalist who is also paid by the Russian government for writing over 1,000 articles. And here the lawyer for NBC Universal, Rachel Maddow, is drafting the response in such a manner to suggest that the reporter at the OAN is being paid by Sputnik. The admission, if there was any such admission, is that the reporter was paid by Sputnik when that reporter wrote over 1,300 articles for Sputnik. Was in the past tense, where this lawyer is drafting the is in the sort of passive current tense to suggest that it is still ongoing. And this is not done by accident. This is done specifically so that if it is not corrected somewhere, either in the response to the response or in the legal proceedings, it can be used as something of a tacit admission. Look, they never corrected the is when we suggested that he is being paid for by Sputnik while employed by OAN, therefore it makes Rachel Maddow's statements true. And we're also going to see yet another wonderful intellectual sleight of hand, which consists of sucking and blowing at the same time. Legal sucking and blowing at the same time, and you'll see what I mean when I read the next paragraph. Ms. Maddow's statement about OAN is also a protected opinion based on disclosed facts. In her broadcast, she stated the facts acknowledged in your letter concerning Mr. Ruse's compensation by Sputnik and Sputnik's funding by the Russian government. She then expressed her view that the implication of these facts is that OAN really, literally is paid Russian propaganda. And then pivoting from the subtly inaccurate characterization of the admission in the original letter of demand, the lawyer goes on to cite the dictionary. Merriam-Webster defines literally to mean in effect and states that it is used in an exaggerated way to emphasize a statement or description that is not literally true or possible. Similarly, Oxford Dictionaries defines literally to mean used for emphasis while not being literally true. Ms. Maddow's comment could not have been reasonably understood to mean that the Russian government made checks payable to OAN. Indeed, she specifically noted who was paid by Sputnik. Use of the word literally here is the kind of figure of speech that connotes opinion and thus cannot give rise to a defamation claim. Your client therefore cannot assert a valid claim against the Rachel Maddow Show arising from the challenged statement. If you have any questions or would like to further discuss this matter, please feel free to contact me at blank. Best regards. Best regards? I once had a mentor, senior partner lawyer tell me that you're better off not ending letters with best regards. Why? Because how do you end a letter when you are acutely unhappy with opposing counsel? You're not going to say best regards at the end of that letter. I was always told to tone it down to kind regards or regards so that you never actually have to change how you end a letter regardless of how you are feeling about that attorney at the time of drafting. But whatever, irrelevant parentheses, let's get to the substance of what we just read. We quite literally just witnessed as much legal sucking and blowing as one can ever see at the same time, and I am using the term literally. On the one hand, the lawyer is saying that the OAN acknowledges the facts at the base of the impugned allegation, therefore it is substantially true and not actionable. And in the next breath, the lawyer says that it is a statement of opinion and therefore protected speech. In that same breath, the lawyer argues that when Rachel Maddow used the term literally, she did not use the term literally. She used the term literally metaphorically or metaphysically or spiritually, I don't know what, but she did not use the word literally. And so when Rachel Maddow said that the OAN is really literally Russian propaganda, she actually meant it not literally and in a way that nobody could take as a fact, even though it's based on facts and therefore not actionable because it's substantially true. Try to say that 5 times in a row. And this is a typical lawyer response, like saying the sky is blue, but if it's not blue, it's because there's clouds in it. And it's what makes it so frustrating to deal with lawyers. They can literally say A and not A in the same letter. I'm not blaming the lawyer for NBC Universal or Rachel Maddow. She's doing her job. And it's a strategic decision that she's making to cover all of her bases. I tend to think that taking mutually exclusive positions or ostensibly mutually exclusive positions in the same letter is strategically disadvantageous. I might have held off on what I perceive to be the weaker legal argument that it was a statement of opinion and she didn't use the word literally. I might have held off with that argument and saved it for a rainy day if and when it were to be needed, and only harped on the fact that she was stating facts acknowledged by OAN, they are substantially true and therefore not actionable. If I am the OAN's lawyer, I am taking this response letter of demand and I am taking what I'm going to argue are mutually exclusive positions as an admission that there is something wrong here. That would be the argument I would raise, but on the substance of this dispute, I think the OAN is going to have an uphill battle. I think they might have an uphill battle because there might be enough admitted facts to draw something of a connection that would at least make the statement not maliciously false. Because remember, in order for the OAN to succeed on this claim of defamation, not only would the statements have had to have been false, but they would have had to have been uttered with actual malice. And given what will likely be certain admitted non-controversial facts, it might be difficult to prove the actual malice part. There might even be an argument as to whether or or not it is substantially true in the first place. Substantially true in that the reporter was once paid for by Sputnik, which is funded by the Russian government, and therefore, it's not maliciously false to say that they are literally Russian propaganda. I am not saying I believe that. That is just going to be the argument that is going to be had. Personally, I do think Rachel Maddow uttered that statement as a literal fact and not as a metaphorical literal fact. Whether or not it might also be her opinion, she was in fact stating that fact to convey it to her viewers that the OAN was literally Russian propaganda. Now, I will obviously literally be doing follow-up vlogs on this lawsuit if and when there are developments, but they are obviously on hold for a little while. For this vlog, I just wanted to walk you through a lawyer's letter in all their beauty and splendor. And with that, if you like my videos and content, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. Support links are in the video description, but above all else, take care of yourselves, be safe, stay healthy, and now you know your vlog. Peace out. Booyah.